On the record in 2023 TR 1273, State of Kansas versus Tommy Morgan Tibbetts. Jared Regier for the state. And this is one charge of failing to wear a seat belt. Ah, there's Mr. Tibbetts. You are Mr. Tibbetts, is that correct?
Yep.
All right, and you're still wishing a trial on one count of failing to wear a seat belt, is that correct?
Yes.
All right, we probably talked about diversion at a prior hearing, Mr. Tibbetts. Do I understand you do not want to pursue diversion in this case?
Nope.
Okay. All right. With that being said, Mr. Regier, do you have any opening statements?
Your Honor, the state would waive opening statements at this time.
Mr. Tibbetts, any opening statements at this time, or do you wish to waive?
Well, only statement I got is I read the law over and over again, and it doesn't put a time limit on how long I can be hurt.
All right, please call your first witness, Mr. Regier.
Yes, Your Honor, the state would call Master Trooper Cale Collins to the stand.
Please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Would you please state your name for the record?
Trooper Cale Collins.
Where are you employed?
With the Kansas Highway Patrol.
And what is your professional title in that capacity?
Master Trooper.
How long have you worked as an officer?
For over 22 years.
All right. And were you on active duty in your professional capacity on April 4th of this year at approximately 9:47 a.m.?
Yes, I was.
Okay. So at that time, where were you at?
I was southbound on Haverhill Road from 6th Street and El Dorado.
And did you at any point arrive at an intersection?
Yes, I did.
Okay. Are there any stop signs at this intersection?
There is a traffic light.
Okay. And when you say southbound, were you in a vehicle or on foot?
I was in my vehicle.
Okay. Could you, now you've touched on this briefly, but could you please describe a little more about the intersection? Is that within city limits?
It is. It is.
Any trees nearby?
No.
Are you familiar with KSA 8-2503?
Yes, I am.
And what does that say about adult drivers and seat belts in moving vehicles?
It says they have to be worn when this vehicle's in motion.
Your Honor, at this time, I respectfully request the court take judicial notice of KSA 8-2503.
Judicial notice is taken.
So on the date and time we've already mentioned, April 4th this year, 9:47 a.m., did you see any acts that you consider traffic violations?
Yes, I did.
And what did you see?
Like I said, I was southbound on Haverhill. I observed a red Chevy truck going northbound. I looked over and observed that the white male driver was not wearing his seatbelt. So I turned around on him, caught up with him, and there was a truck tractor between me and him. We turned eastbound onto 6th Street. The truck tractor got out of my way. I got behind him, and the defendant, I again observed he wasn't wearing his seatbelt. I activated my emergency lights, and I believe it was his business that I pulled into where he works.
Okay. Now you mentioned that it was a red Chevrolet pickup. Do you remember what year the Chevrolet was built?
No, I mean, I do based upon the notice to appear I wrote. It was 1992.
And on this particular Chevy, do you recall how many rows of seats the Chevrolet had?
It just has the one row.
And was this particular Chevrolet from 1992 equipped with seatbelts?
Yes, it was.
Now you've already mentioned that when you saw the Chevrolet moving northbound, you saw the driver not wearing a seatbelt. Would you describe the driver of the Chevy generally as an adult or a juvenile? An
adult.
And how did you reach this conclusion?
Upon stopping him, he provided a driver's license, and I looked in the window at him.
Do you see the driver of the Chevy present in the Zoom conference?
Yes, I do.
Could you please point them out and give a brief description for the court?
It is the white male, bald head, goatee, very good one, and I think it's a camouflage shirt.
Okay. Your Honor, let the record reflect that the witness has identified the defendant.
The record shall so reflect.
When you conducted the traffic stop, were you actually able to speak to the defendant?
Yes, I was.
Okay. And did you discuss the defendant's driving without a seatbelt?
I did. He explained that he had a doctor's note that exempted him from wearing the seatbelt. I asked him to provide asked him where it was at, and he advised it was at home in his safe, to which I went back to my patrol car, wrote him the ticket, and explained to him that it would be his responsibility at this point, since he didn't have it on him, to provide that documentation to the court.
Did the defendant ever provide the alleged doctor's note to you subsequently to the stop?
No, he did not.
Barring any redirect, no further questions.
Very well. Sir, it is your opportunity, that is Mr. Tibbetts, to ask any cross-examination questions of the trooper. It's not yet your time to testify, but you certainly can ask him any questions if you like.
No, I have no questions for him.
All right, very well. Any further evidence, Mr. Regier?
None from the state, Your Honor.
All right, so the state rests.
The state does so rest, Your Honor.
All right, Mr. Tibbetts, do you have any witnesses, including yourself at this time? You don't have to present any, but you can if you wish.
Just myself.
All right, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. And you are the defendant, Tommy Morgan Tibbetts, is that correct?
Yes.
All right, tell me what you would like the court to consider today.
Well, the state attorney has the letter from my doctor. It's like in 2014, to get everyone caught to date, I was involved in a head-on collision in a semi versus a Mitsubishi, which Mitsubishi ain't going to win the fight, by Sally Rao, which I don't know, most people probably know her, about 5 miles south of Harrington, Kansas. She died. I pulled her body out of the car with her seatbelt was around her ankles when I took her out of the car, so she wouldn't burn up. I sustained damage to the left side of my body caused from a seatbelt, that I can't carry nothing in my left hand. Seatbelts, when that puts pressure on my left collarbone, makes my left side of my body go numb. I have pain from basically my neck clear down to the back side of my left knee, depending on the occasion how I sit. When I drive a vehicle, I got to sit on the right side of my butt cheek, because if I lean the other way, it freaking causes pain. Like this chair I'm sitting in, and most chairs in courtrooms are painful. I got to lean forward or lean all the way back like I'm slouching, being disrespectful, because I can't sit upright because it causes pain. The tendon that they stick that big ass needle through to kill your sciatic nerve doesn't work on me, because it tore the tendon in my back. So all that stuff seeps back out. So that's not an option for me. And then we're up to the point where I did physical therapy, and I'm still doing physical therapy. And the doctor, my therapist, whatever, from El Dorado Hospital, wrote me that letter that I showed to the prosecutor.
Objection, Your Honor, not in evidence.
Well, Mr. Regier, I think that puts us in a little bit of a difficult position, because he says you have the letter, that he gave it to you. Are you still maintaining your objection, Mr. Regier?
Your Honor, my understanding is that my office did receive some correspondence of some kind. Of course, in my capacity as prosecutor, I do not represent the defendant in these proceedings, nor can I speak to any veracity or authenticity of the alleged document. State would respectfully suggest, if the defendant does intend to refer to that, first, that needs to be admitted into evidence, and secondly, it would be up to the defendant to produce the same evidence to the court.
So this document that you said, Mr. Tibbetts, you gave to the prosecutor, is it a copy of something or is it an original?
Yes, ma'am. It's a copy of the original letter I gave to his receptionist, I guess, at the prosecutor's office, the lady that sits up at the front. You got to push the button, let you in the door.
Mhm.
Last time we spoke, he had the letter with him at our hearing in the
Okay.
garage, in the carport, whatever it's called. And
So you gave him a copy. Where's the original?
at my house in the safe. If we can have a recess for 15 minutes, I can be back with it.
And do you have the doctor who prepared the statement here to testify?
No, ma'am, he retired. He's no longer employed with Susan B. Allen.
I remember some discussion of such an exhibit at a prior hearing, but I thought that had some date limitation on it. Am I remembering that correctly?
Talking to me or?
Yes, to you?
Yes, ma'am. It has basically, it's kind of just what off the top of my head says, to whom it may concern, please excuse Mr. Tibbetts or Tommy Tibbetts from wearing his seatbelt, blah, blah, blah. Something about 4 weeks and something like that, because that's when he retired and I went from him being my physical therapist to a lady.
Again, Your Honor, this document is not in evidence yet, nor has the defendant laid any foundation testimony as to it.
Yes, Mr. Tibbetts, I see a number of problems wrong with trying to proceed with what this document may or may not say. First of all, we don't have the actual document. We don't even have a copy of it. We don't have the preparer of that document to testify that, yes, that's his document and he prepared it. And even more, it sounds like it was only good for 4 weeks. So
Your
if
Honor,
we had it, it sounds like we could only consider it for that period of time. Yes, Mr. Tibbetts.
if you want, you guys can go ahead and find me guilty. I can file an appeal and take it to another judge, and I'll get a couple more copies to the prosecutor, and we can just continue that way. Because
Well,
I did ask, the court had asked me to do from the very first time we met in the carport to get whatever that letter, a copy of it to his office. I did so. He brought it to the second hearing that I had in the carport, and everybody read it. And then I still pled not guilty, and we're here today. I don't know what else to do besides have God come down and maybe Jesus as a witness saying, yeah, he was in an accident. This young lady died, and which the trooper could probably call and get proof of that, because she was a triplet. She graduated that year and was going to school in Manhattan to the Christian college up there to be a grade school teacher. And she died that fall, or that spring, I guess you'd call it.
And that would have been 2014.
Yes, ma'am.
And
I know more about her than most of my nieces and nephews because of this accident. And I live with the pain every day. And if it wasn't the fact with that letter, that officer could have wrote me a ticket, and I tell him the route I take from home to work, and he could park and write me a ticket again the next day. And that just would be how life would be.
But again, you at the last hearing and again today, you've said even if you produce that statement, it restricts your wearing a seatbelt for only 4 weeks. And that would have been in 2014, correct?
Not correct. It's just stating I was under his care for the next 4 weeks. And then I went to another physical therapist.
All right. Well, okay. Well, we still have the problem that you don't have the original. You don't have the person that can testify to its authenticity. And that's what Mr. Regier is talking about when he says foundation. So at this time, we're going to have to proceed with what you do have.
I plead not guilty. I'm just asking you to find me guilty so I can appeal this decision.
Well, with the evidence I have before me, sir, I do find you guilty.
Okay. Thank you for your time.
Hold up. You have 14 days to appeal this decision. You appeal it to the Kansas Court of Appeals. This is not small claims where you just appeal it to a different judge. Your fine in this case is $30. I don't believe that the statute directs us to assess court costs. Am I correct on that, Ashley?
Correct. There are no court costs.
Okay, I'm going to order that you have that $30 paid at the clerk of the district court or on paykscourts.com within 14 days.
I'll leave here, go to the clerk to file my appeal papers.
All right, and I'm going to order that you pay I'm just going to make it a $30 appeal bond. But remember, it's not enough just to file the notice of appeal. You have to actually follow through with the Court of Appeals.
Oh, I will. I'll take it to the
Okay.
state Supreme Court.
If they will hear it, you're certainly welcome to.
I'll take it to my brother-in-law. He's a state Supreme Court judge.
Very well.
That it.
Yes, sir.
All right, thank you.
And Your Honor, is that 30 days, $30 cash on the appeal bond?
Yes, cash appeal bond. Thank you.